Judge Coffin, Mrs. Coffin, Chief Justice Watson, Dean Zillman, honored guests. I'm honored to be the fifth person in the lecture series that honors Judge Coffin. Another great judge, William O. Douglas, in the second volume of his autobiography on the court years, included as a prelude the following words written a century earlier by Henry David Thoreau in Walden. If a man does not keep pace with his companions, perhaps it is because he hears a different drummer. Let him step to the music which he hears, however measured or far away. I thought I would share with you some of the music I heard during my career as I tried, using Judge Coffin's words in his remarks on the occasion of the first Coffin lecture 4 years ago, to keep alive the old ideal of public service. And frankly, to the younger people here, I hope to influence some of you in how you spend the rest of your professional life. In the third Coffin lecture, my former colleague and good friend Pat Wald, a judge of the District of Columbia Circuit Court of Appeals, talks about measuring success for public interest lawyers in what I thought were fairly traditional terms: winning or losing, advancing a group's special interest, or furthering society's interests. All true, of course, but for me there was something else. If you can listen to a few powerless people who have never been listened to before, local black folks in Sunflower County, Mississippi, who had never been allowed to vote, or a shoplifter with mental health problems who had been brutalized in Alabama's prisons for 30 years, if you can listen to them and have their voices heard, you have made a difference. By listening to men and women in terrible circumstances, and by assisting them in their desperate search for self-respect in a place often devoid of any dignity of its own, a lawyer, I believe, can make a difference. The Bill of Rights in our Constitution is a marvelous document. It is a promise of equality, fairness, justice, but it is only a promise. It is not self-executing. For the Bill of Rights to have real meaning, to have vigor and life, there must be a deep commitment on the part of many segments of our society. The courts, the executive branch, the legislature, at the federal, state, and local levels, all must have commitment and show leadership. There must be a commitment by lawyers, and most important, I think, there must be people willing to speak, to stand up and be heard. As Judge Coffin mentioned in his opening remarks, one of the most important courts in the history of our nation was the old United States Court of Appeals for the Fifth Circuit in the 1950s, 60s, and 70s, before it was divided into the Fifth and the 11th Circuits. The court was led by four great judges, two Republicans and two Democrats, Elbert Tuttle, John Minor Wisdom, Richard Reeves, and John Brown. The book, Unlikely Heroes, tells the dramatic story of that court and has one chapter on the role of the lawyers in those years. It ends with an interview with Judge Tuttle, and he says, critical as their role was, lawyers could act in civil rights cases only because there were those who insisted on exercising their rights as American citizens. We became what I consider a great constitutional court, Tuttle reflected, and I think we largely have to thank the black plaintiffs for that. I've been talking most of the day, and I hope my voice holds out. As Judge Wald did in her lecture 2 years ago, I'm going to elaborate on my opening comments in a few moments by talking briefly about two cases I worked on, one involving the struggle for racial equality, the other involving rights of prisoners. But before moving to those cases, I want to share two themes with all of you. And again, I'm talking primarily to the future lawyers here tonight. First, contrary to what you may have heard or believe, there are today exciting opportunities and new frontiers in human rights litigation. And the courts, including the federal courts, are not hopelessly resistant to public interest law. Second, as you embark on your legal careers or whatever else you do with your law school education, I urge you to proceed with a commitment to moral reasoning based on ethical values and standards, not as narrowly defined by the canons of ethics, but in the broader sense, with a feeling of social responsibility in the tradition of Judge Coffin, a commitment to public service. I meet large numbers of law students and young lawyers in my work and in my travels, clerks in our own office, and often hear the same lament. They were born too late. All those frontiers, those exciting legal challenges of the late 50s and the 60s are done and gone. Even if there were issues left, they say, the hostility of the courts, or the Reagan legacy, make it impossible to accomplish anything. None of that is really true, and you can still make a difference. Compare for a moment the situation today with when I left law school 45 years ago. Today, there are thousands of public interest lawyers working in many different fields. The ACLU alone employs more than 150 full-time lawyers today. When I finished law school, the National ACLU had one lawyer on staff. There were 3 or 4 staff lawyers at that time at the NAACP Legal Defense Fund, and there were a handful of lawyers in private practice who did a fair amount of civil liberties and civil rights work. It is clear to me that there is much to be done in environmental law, consumer law, civil rights, women's rights, the rights of lesbians and gay men, the rights of the physically disabled, the mentally ill, the elderly, and the homeless. There are few lawyers engaged in heroic legal efforts to challenge the increased application of the death penalty in the United States, who desperately need help now that the federal government has stopped funding the death penalty resource centers. There are new legal battles to be fought on behalf of immigrants and of a woman's right of choice and reproductive freedom. You can still, believe me, make a difference. It is true that the federal appellate courts have, in the past 15 years, become a bit more hostile to the rights of individuals. That does not mean we quit. It means we work harder and devise new strategies, new mechanisms. The struggle for civil liberties consists of many important small battles that lead to and support celebrated cases. Litigating under the broad and vague language of the Constitution allows judges a great deal of discretion to interpret and be influenced by ideology. We need to explore extra constitutional sources of relief for public interest litigants, federal benefit and anti-discrimination statutes, such as the Rehabilitation Act of 1973, the Aid to the Disabled Act, the amendments created by the Civil Rights Restoration Act of 1989. We need to explore state constitutions and statutes and the state court systems. We need to look at contract theories and international law and the application of international human rights standards. We need to try to negotiate imaginative settlement agreements and consent decrees, in some cases without litigation. For me, the most exciting new frontiers are in the international human rights field. The world is getting smaller every day. The newly emerging democracies in Eastern Europe, Sub-Saharan Africa, and Latin America are exploring the development and implementation of human rights standards for their prisoners and other institutions for the first time. I was involved with a task force that updated the 1955 United Nations minimum standards for the treatment of prisoners, cross-referenced them to more recent international treaties and covenants, and then developed a manual for their implementation. The manual was presented jointly by the task force and the UN crime section in Vienna to the 9th UN Congress on Crime Prevention and the Treatment of Offenders in Cairo last year and adopted overwhelmingly. It is now being used as a guide to the prison systems in Albania, in Moldavia, in Belarus, in many of the sub-Saharan African countries. On a few occasions already, American courts have referenced international human rights standards, reluctantly, but they're beginning to look at them to support a line of reasoning. Unlike the broad general language of our Constitution, marvelous document that it is, many international standards are very specific on human rights issues. In the future, we shall be urging the UN standards, the Council of Europe standards, and others on our courts. We shall be arguing American human rights issues in international courts. A whole range of exciting new opportunities is out there waiting for you. After more than 4 decades of lawyering, I can tell you this. The law is not an ideal vehicle for social change. As lawyers, however, it is what we have to work with, and in some times and places, it actually does have a role to play in building a just social order, and you can make a difference. Now, the two cases I wanted to tell you about. First, a little bit of background on the Lawyers' Constitutional Defense Committee that Judge Coffin mentioned. In 1964, you may remember that the civil rights organizations announced a Freedom Summer. They were inviting a few thousand college students from around the country to come to Mississippi, Alabama, Louisiana, help register black citizens, help teach at freedom schools, just help by their presence to show some solidarity with the local folks who were trying to make a difference in their lives. And there was a great absence of lawyers down there. At the time I went to Mississippi, they were a state with 1 million black population. There were 4 black lawyers, one of whom was really not a practitioner at all. The other 3 very courageous men, not a great deal of legal ability, but a lot of courage, and that was it. There was a great deal of infighting and backbiting between the various established legal groups at that time for all kinds of silly political reasons. And so the chief legal officers of the major civil rights and human rights organizations, and I gather Father Drinan said something about me last night, he was one of them, the National Catholic Conference for Interracial Justice, the National Council of Churches, the ACLU, CORE, the NAACP, SNCC, the Southern Christian Leadership Conference, Dr. King's group, the American Jewish Committee and the American Jewish Congress, all brought together their chief legal officers and created the Lawyers' Constitutional Defense Committee, which later on became a project of the ACLU. And in that first spring and summer of 1964, it was expected that this committee would function through the summer and perhaps into the early fall, and then end at that time, and they recruited volunteers. I volunteered for 2 weeks in the late spring of 1964 and stayed almost 5 years. Melzar was one of the staff lawyers down there for the NAACP Legal Defense Fund. We worked very closely together, all the legal groups did, after the political stuff was left up in New York and Washington. We used volunteer lawyers extensively, and my group worked primarily in 3 states, Mississippi, Alabama, and Louisiana. We had offices in all 3 states. I ran the project from the Jackson office, but I had full-time staff in the 3 states. We had a New Orleans office, and the chief staff person there was a young lawyer by the name of Richard Sobel, who had clerked for a Second Circuit judge, then was a young associate at Arnold and Porter, then Arnold Fortis and Porter at the time, one of the prominent Washington law firms. He too had come down for 2 weeks and decided to stay, and has never been back to Arnold, Fortis and Porter since. In any event, he became my staff lawyer in New Orleans and ran that office very successfully, a very brilliant lawyer. And this case arose in October of 1966. I don't know whether any of you have ever heard of Judge Leander Perez and Plaquemines Parish. Plaquemines Parish is that strip of land along the Mississippi Delta below New Orleans, which enters into the Gulf. And Plaquemines Parish is, that's the equivalent of a county, is that small strip of land on the other side of the river. And it had been run since the 20s by Judge Leander Perez, a man who had been a district judge in 1920 to 24, but still used the title, and was really the king or the emperor of Plaquemines Parish, which was an extraordinarily mineral wealthy piece of land. They had enormous mineral deposits, sulfur and oil, the beginning of offshore oil there. Judge Perez had put through a constitutional amendment in Louisiana to create a separate special form of government in that parish so that everything was controlled by a parish council, and you know who the president of the council was, Judge Perez. And the district attorney was Leander Perez Jr., and the vice president of the council was Chalon Perez, his older son. and they had enormous wealth. If you wanted to get a license to look for sulfur or mineral or oil in Plaquemines Parish, you needed to get a license from the parish council, and you could not get a license from the parish council unless you hired the Perez law firm to prepare this little form and submit it, and the standing fee was $1 million, literally $1 million for a 5-minute piece of work. Leander Perez was a close associate of Senator Bilbo from Mississippi and Jim Eastland from Mississippi. He was a racist par excellence. He was the man who first began to distribute the phony protocols of the Orders of Zion and a number of other racist and anti-Semitic publications. He's a man who bragged that if Martin Luther King ever came to Plaquemines Parish, they had bought a little island in the Mississippi that was snake infested, that had an old Spanish fort on that, and that's where Dr. King would be placed if he tried to do anything in Plaquemines Parish. In any event, he was also excommunicated by the Archbishop of New Orleans because he physically tried to prevent the integration of the Catholic schools there in 1962 and 63. In October of 1906, the Plaquemines Parish schools were finally integrated by a few young black students, in October of that year, a man by the name of Gary Duncan, a 20-year-old black fisherman, married with a young infant child, lived in Plaquemines Parish all his life, was driving home from work and passed the school and saw a bunch of kids on the sidewalk outside of the school, 2 of whom were his nephews, 2 12-year-old black kids who had been among the few who had integrated the school. And he saw that they were surrounded by about 5 or 6 white boys about the same age, 12 or 13. And it looked like there was an incident or something was going on, so he pulled over in his car and got out and said, "What's happening?" And there was a little pushing and shoving between the kids, and the kids, his nephew said they were taunting and teasing and threatening them. And he said, "Okay, well, get in the car and I'll take you home." And then he then said to one of the young white boys, touching him on the elbow like this, "Go run along and go on home." Just like that. Across the street was one of the members of the parish school board, a man by the name of Herman Landry, who had resisted the integration, who was a pal of the Perez's. He went to the phone and called Leander Jr., the DA, and said, "I just saw this, using a racist term, this black man touch that boy, and I think it was an assault." Sure enough, 2 days later, although the police investigated and found there was no assault, Gary Duncan was arrested and charged with battery, common law battery. That is a touching without permission and without the intent necessary to commit a real assault. He was charged with this battery, which carried a possible penalty of 2 years. It's a misdemeanor. Now, Louisiana is a civil code state, the only one in the country, and there's this peculiar distinction in that criminal code. Misdemeanors and felonies were not divided by definition in the context of the code itself or the crimes, but only by the punishment. You could be convicted of a misdemeanor and get up to 9 years, 11 months, and 29 days in a county prison and still be charged with a misdemeanor and not be entitled to a jury trial. A felony was any crime where you were punished by a term of years in the state prison at hard labor. It was a real carryover from 18th century codification. So he was charged with this misdemeanor of battery, could have gotten 2 years, and his family called our office in New Orleans and asked for help. Dick Sobel and one of the black lawyers in the office, our local counsel, went down there, put up the bail money, got him out, and then looked at the statute and saw this peculiar, bizarre thing that a man could face 2 years in prison, and there was no right to a jury trial, and they knew that trying a case like that in Plaquemines Parish before Judge Leon, who was also a crony of Judge Perez, was a futile exercise. And so they demanded a jury trial, and it was rejected, of course, saying you're not entitled to a jury trial, this is only a misdemeanor. And they decided that would be at least one issue that they would try to preserve for ultimate review in federal court. Duncan, after he was released from prison, was tried without a jury. He was convicted, rearrested, arrested him about 18 times in the course of this trial at every opportunity. Had to put up another bond to appeal to the Louisiana Supreme Court. The appeal was rejected there. He was rearrested, and then we decided to go directly to the Supreme Court of the United States rather than go through the lower federal courts with a habeas kind of thing. And we filed a cert petition in the Supreme Court, and Dick Sobel went down to Plaquemines Parish to Pointe-a-la-Hatch, the parish seat, to get Duncan out of jail again. And he did, and after he got him out of jail, this is now February of 1967, he stopped at the telephone booth to call the office and report that he was heading back to New Orleans, which is an hour away. You've got to cross the river in a ferry boat. There are no roads going directly into the... Guess who owns the ferry boat line, right? Judge Perez. And at that point, Dick Sobel was arrested and charged with practicing law without a license, a crime in Louisiana. It is both a civil, there's a civil violation, but there was also a part of the criminal code that made the unauthorized practice of law a crime, and that's what he was charged with, and he was put into the parish prison. I was in Jackson at the time, and I was called by one of the other staff lawyers in New Orleans to tell me that Dick Sobel had been arrested. This was about 2 o'clock in the afternoon. I immediately called Tony Amsterdam, who was then now a professor at NYU Law School, was then still at Penn, and one of our gurus, one of the most brilliant lawyers in the world, not just America. And we had been prepared for this. We had had a previous arrest the year before of one of my Alabama staff lawyers. That case got mooted out when the state agreed to drop the charges of unauthorized practice because this fellow wanted to leave Alabama anyway and go back to California. But we knew at some point we were going to face this business of practicing law there in association with local lawyers, living there but not being admitted to the local bar. I was admitted to Mississippi under the reciprocity statute, thanks to Judge Cox's intervention, but Dick Sobel was not. And so we had a framework of a complaint with theories worked out already, and I discussed it with Amsterdam, alerted him that we needed to take action. I flew to New Orleans, got there about 7 o'clock in the evening, and began what we used to call then, and Mel, so I will remember these, an all-nighter. We work all night and get to court at 9 o'clock in the morning. And it was important, we felt, strategically and for the benefit of our clients, because Sobel's arrest was front page in the New Orleans Times-Picayune, the major newspaper, that Friday morning. And we needed to send a message not just to the state officials, but to our clients that, hey, you know, the ball game is not over, because the feeling of desperation that I heard when they felt that they would no longer have access to our lawyers among the civil rights community was really rather dramatic and rather poignant. So we needed to get that complaint filed, and at 9 o'clock on Friday morning, I filed a 24-page complaint seeking to enjoin his prosecution and seeking to declare the statute as applied to his conduct unconstitutional. Not on its face, but as applied to Sobel's conduct. That meant at that point of time, of course, this is before the change in the federal jurisdictional statutes, that if you're challenging the constitutionality of a state statute, it was required that that be heard by a 3-judge federal court, 1 judge from the Court of Appeals and 2 from the district court. I happened to stop in and visit with Judge Wisdom after I filed the complaint. He had been reading the paper. He knew Sobel, and Judge Wisdom and I had been friends for some years, and he asked me about it, and then he immediately took me in next door. Judge Tuttle was visiting from Atlanta and started talking about it. I said, wait a moment. No. I said, you know, Judge Tuttle is going to have to appoint this court. You are one of the Louisiana judges. There are only two of you. You may be one of the judges. Let's not discuss it. So the discussion stopped immediately. They just hadn't been thinking it. And Judge Ainsworth, the other Fifth Circuit judge from Louisiana, was appointed to the court together with two district judges, the Chief Judge Hebe, Fred Hebe, and another judge, Fred Casabry, both really competent, thoughtful, decent judges who knew of our work and who I think respected our work and who would give us a fair shake. Some of the strategy that went into to dealing with these cases, you couldn't just deal with these cases on their facts. One of the things we were very concerned about was that there were a series of cases working their way up to the Supreme Court, dealing with the ability and the authority of federal courts to enjoin state prosecutions, to interfere in state court proceedings. And we were worried about that happening at some point in the process of this trial. So we worked very hard to get the United States Department of Justice to intervene, because the United States Department of Justice is not precluded by any of the jurisdictional statutes. If they feel that it's in the interest of the United States to attempt to enjoin a state court prosecution, the anti-injunction statute doesn't apply to them. And we were successful in getting John Doerr, then the Assistant Attorney General in charge of civil rights, to agree to intervene on behalf of the United States. And that solved our main jurisdictional problems. And then we had some other strategic issues. We wanted to prove in this case that four things, really: that there were very few black lawyers in the state who could handle these kinds of cases and clearly could not handle the load of cases. We wanted to prove that the white Louisiana lawyers generally would not handle civil rights cases. There was one white lawyer at that time who would handle a civil rights case. He was excommunicated by his church for doing that. The third, that if one would come forward, with the exception of Jack Nelson as one man, that he or she wouldn't be trusted by the local black community for historical reasons. And that we had some special expertise in handling civil rights cases, and that the combination of these factors would lead to the conclusion that this prosecution was made in bad faith, that this statute of criminal violation could not be applied to Sobel's conduct because it was constitutionally protected under these circumstances. And lined up on the other side were, we saw that there'd be 17 lawyers in the courtroom, because you had the district attorney prosecuting the case. Because it was a state statute that was being challenged, the Attorney General's office came in with 3 lawyers on the side of Plaquemines Parish. The Louisiana Bar Association, whose feelings were terribly hurt by the allegations in the complaint, intervened against us with retaining 2 of the biggest law firms in New Orleans. Named partners appeared in court. The New Orleans Bar Association similarly intervened against us, and the Louisiana Criminal Lawyers Bar Association. And we knew from the way they spoke that each one of these lawyers was going to want to get on their feet and do their rhetoric. There will be a lot of press coverage in the case, and there were 17 that we counted. And we had a fairly good team, too. Tony Amsterdam, who I mentioned was one of the real geniuses of the civil rights movement, was going to be there. The Justice Department lawyer assigned by John Doerr was a fairly young, inexperienced lawyer, but a very competent one, Owen Fiss, who now is a professor at some other law school in New England down in New Haven, I forget the name of it, and an authority on federal court practice and jurisdiction. Owen was there for the Department of Justice. And then the 2 of our local black lawyers, both of whom later became judges, Bob Collins and Nils Douglas, and myself. And we made a decision, really at Tony Amsterdam's suggestion, that one of the ways we could prove our case and illustrate our special expertise was that just one of us should take on the 17 on the other side. And I was the lucky person. And I was the only lawyer who spoke during the trial, with the exception of Owen Fisk for the government. Putting a lot of pressure on him, said, you're to do two things, Owen. At the end of our case, you're to stand up, at the beginning of our case, you're to stand up and say, you are here to represent the interests of the United States of America, and then you sit down. And at the end of our case, you're to say that the United States of America joins in with plaintiff's case, and then you sit down. And don't say anything else. And he agreed to do that. Because that's what we wanted the court to hear, that there was a larger governmental interest involved, in addition to the interests of Richard Sobel and the lawyers, Constitutional Defense Committee. And so during the entire direct case, I put on all the witnesses, and I did all the cross-examination in the defendant's case. The direct case basically was Sobel testifying about his background and experience, his judicial clerkship, his writings, some of the trials he'd handled. We put on some of the black lawyers in the state to talk about the problems that they had in handling civil rights cases. One of them talked about being before a state court judge in Baton Rouge who pointed out his window to a tree and said, that's where we hang nigger lawyers. This really happened. That man later became a member of the United States Congress, the judge. We put on the plaintiffs, the civil rights folks, people from the Bogalusa Voters League, people from the Madison Parish Voters League, who talked about the great shock they had when they read about Sobel's being arrested and how they felt the movement would evaporate if they did not have access to lawyers from the Lawyers Constitutional Defense Committee, and how they had this special trust for us and our few local black colleagues, and the years of experience that they had in trying to get local white lawyers to do things, and the fact that they wouldn't do these. And so we pretty much proved the 4 points that I wanted to set out, point out. An interesting side light here, for those of you who know Tony Amsterdam, we didn't have the money to order daily transcripts or anything. And what Tony Amsterdam did was each evening after court, he would write out the proposed factual findings from that day's testimony. And at 6 o'clock the next morning, he would give me typed, just proposed factual findings, which were really the guts and the heart of what we had proved that day, or what we had extracted in cross-examination that day. And it was better than a running transcript, because this was the heart of everything rather than everything itself. The man really was a genius. He never slept in those days. And by the way, on this strategic point, I later met Judge Ainsworth at an ABA meeting, and he said, I've always wondered about that Sobel case. All those lawyers sitting at your table, but you were the only one who spoke. Were you trying to tell us something with that? I said, well, did I? Then the state went on, and they put on about 25 lawyers. But we also put on some statistical information. We did a search of all of the reported West Publishing cases for a 20-year period under the various civil rights annotations coming out of Louisiana, and could not find one where there wasn't an out-of-state lawyer, either from the NAACP Legal Defense Fund or the National Lawyers Guild or some other group. There were no cases, no civil rights cases, handled exclusively by local lawyers, other than the few black lawyers during a 20-year period. And we put that into evidence as well. On that case, they put on about 25 lawyers, each of whom basically said the same thing. Well, I'd be glad to handle these civil rights cases. Nobody's ever asked me. And it just, at one point I even stopped cross-examining most of them, because it just obviously was foolish and not making an impact on the court. And then they came up with a man by the name, who I'll never forget, Thomas McBride, a lawyer from Plaquemines Parish himself. And he said on direct examination that he would defend a Negro in a civil rights case. And I thought I heard him say something about if he was a local Negro. And then he was turned over to me, and I asked him 2 questions. I said, I think I heard you say, correct me if I'm wrong, that you would not hesitate to handle a civil rights case in Plaquemines Parish if it were a local Negro? He said, that's right. And I said, and this, I've got it written down here, so that if 3 Negroes from Chicago came down and picketed the courthouse in Pointe-a-Hatch because they had white and colored drinking fountains, which they still had, and were arrested, you would not represent them? And he said, I would not. I am a white man first and foremost. And that was the heart of the case. And Judge Ainsworth, who'd sort of been dozing at the, this repetition of these people, I saw him sort of poke Judge Casabri. What did he say? And that was the case. And you can imagine the temptation then. I was working from a trial book. I said, my God, the cross-examination I can now do on this man. I said, well, what else could I prove? And to my own credit, I closed that book and sat down. And the courtroom was still. And there was nothing more you could do. I mean, the 2 questions had done it all. And I still remember that and get chills when I think of that. The entire courtroom was still. We got a decision a few weeks later. They enjoined the prosecution. They found the statute was unconstitutional as applied, that the prosecution was in bad faith, and said that he could not be prosecuted for practicing law without a license, and a lot of other good language in this decision. Some really important language which gave us, we felt, protection for all of our work in the other states as well. In the meantime, the Duncan case went up to the Supreme Court of the United States. Dick Sobel argued it, and it resulted in a landmark decision in Duncan v. Louisiana, where the Supreme Court for the first time said that in a misdemeanor case, if you're facing a substantial punishment, and at 6 months, they sort of suggested, because it was done in tandem with a contempt case, a criminal contempt case, the Bloom case, and that was a 6-month punishment, that you're entitled to a jury trial. And from that point on, misdemeanants charged with serious offenses were entitled to jury trials, and they remanded it to Louisiana for implementation of their decision. And of course, what the Louisiana legislature did immediately was to amend the statute, and they read the decision as saying, well, if you can only get 6 months, then they're not entitled to a jury trial, so they amended the punishment part of the battery statute to max the punishment at 6 months rather than 2 years, and then they wanted to prosecute Duncan again without a jury trial. And so we went back, and they arrested him, and we went back in, got him out on bail, and then brought another action in federal court to enjoin this prosecution. And at this point, we knew that Younger v. Harris and related cases were pending in the Supreme Court on the very issue of when and if federal courts should enjoin state court prosecutions, and we knew that we were not going to do well in those cases. And so we had to anticipate that with this particular action in Duncan. We just couldn't let this guy go to jail in the parish. And so we brought a new action. It was tried before Judge Casabri. I tried this case, and we proved that it was a bad faith prosecution, that there was no crime committed, that the touching was an everyday occurrence. People touched people and said, run along, go home, do this, and that the only reason that he was being prosecuted was because a lesson to teach the black citizens of Plaquemine Parish that if they fool around with a white power structure, they're going to get punished. And we had a lot of evidence to that effect, that it was bad faith. The Perez's were sort of falling apart at that point, and a lot of good testimony. And in fact, Judge Casabri enjoined the prosecution and found that it was not a good faith prosecution, it was a bad faith prosecution. They appealed to the Fifth Circuit, and then Younger v. Harris came down, and interestingly enough, since we wrote the briefs in the Fifth Circuit, this case was really the exception to the Younger doctrine. And in spite of Younger v. Harris, the Fifth Circuit affirmed. They then filed a cert petition that was denied. And so from this one touching, we had, look at the law we made, the right to enjoin prosecution of a lawyer engaged in civil rights practice, right to a jury trial for a misdemeanor, and then the Younger exception, bad faith prosecution, could be enjoined by a federal court. And as I think back on this case, I remember leaving the Supreme Court after the argument, and Gary Duncan, his wife, and his parents were there, Dick Sobel, of course. And when we left and walked down the steps, Gary Duncan looked up at the the inscription on the top of the front of the courthouse, "Equal justice under the law." And he said something about it was so great to be there. He really didn't care anymore whether he won or went to, he could go to jail and do the 60 days, which is what he was sentenced to originally, because he felt he really had won. It was clear that he had been listened to and had been heard, and that was what was important to him. The second case is a prison case, and the prison project, as Judge Coffin mentioned, started in 1972 after Attica in the fall of '71. And in our early years, we were doing a lot of narrow cases, you know, the lawyer's hang-up, procedural due process, which basically doesn't change anything. At least in the prison context, it gets you the fair procedures, and then the prison officials made the same old unfair decisions. And their decisions were then insulated from court review because you had all of these due process procedures. And we were looking to get a court to take a systemic look at prisons, and we kept thinking about Alabama as being one of the, you know, the best fact situations from our point of view. And then fate intervened. The then chief judge in the Middle District of Alabama was Frank Johnson, who later went to the 11th Circuit. And he received a handwritten petition from a 78-year-old prisoner named Worley James, W-O-R-L-E-Y James, which said in a rambling sort of fashion that he'd been in and out of the Alabama prison system for 30 years. He'd just been a shoplifter when he started, and he, you know, he doesn't feel well all the time, and they keep abusing me, and he sort of talked about some of the abuses and being beaten, and they never made me any better, Judge. They keep making me worse, and when they turn me loose, I can't, all the things they did to me, I just, all I can do is go back to prison. And Frank Johnson had had a lot of pro se cases, and a lot of other cases. He'd already done a statewide medical care case in the prison system for the Department of Justice. He had done a statewide mental health case, Wyatt v. Stickney, there. And he decided it was time to look at the prisons. So he certified this handwritten petition as a statewide class action, and then called in a law professor at the University of Alabama, George Peach Taylor, who had worked with us in Mississippi a little. By the way, last night at dinner, Chief Justice Wathen was commenting about some the way in the South nicknames are used. And the Peach reminded me, and I told him about one of my favorites was a fairly good state court judge in Mississippi in the 60s whose last name was spelled S-W-E-A-T-T, and on his official letterhead it said Circuit Court of Bolivar County, presiding N.S. Soggy Sweat. That's true. Anyway, George Peach, and then Judge Johnson, after he appointed him, said, and you need to get some help, Professor Taylor, and I suggest you call the National Prison Project in Washington. I had known Judge Johnson for some years. I had tried a bunch of cases before him in the 60s, civil rights cases, and this was now 1974. I didn't mention that. And so there was a conference, a pretrial, really an early pre-trial conference in November of '74 in Judge Johnson's chambers. And Judge Johnson was a very, very strict judge who ran his courtroom almost like a military establishment, very fair to everyone involved, a very courageous and great judge. I think really a great conservative in the best sense of the word. He just believed that the Constitution applied to everyone. He was not he didn't like criminals particularly. He was an established white Republican, fifth-generation Alabamian, but he believed in the Constitution. And so he laid down the ground rules. He said, I'm not going to let you in this case, Mr. Bronstein, as a lawyer because I don't want to build up legal fees against the state of Alabama. He said, I'm going to have you come in as an amicus with the rights of a party. Now, that's an invention of Judge Johnson. He's the only judge I know of who does that, who allows people to come into a case as amicus curiae with all the rights of a party. He said, if you prevail, you'll be entitled to costs and expenses, but no fees. But I expect you to, to help present this case to the court in an orderly fashion. He then told the Attorney General, the single man there, get some help. He consolidated 2 other cases with this case, so the case ultimately was not known as the James case, it was known as the Pugh versus Locke case. He set, this was November '74, he said, I want to try this case next summer. We said, Judge, it's a statewide case, we need to do a lot of discovery. He said, we're going to try this next summer or else. And you never argued with Judge Johnson. If he said something, if he had to say something twice, you're really in trouble. So we knew that Judge Johnson does not like long trials. He does not like to hear a lot of evidence unless it's absolutely necessary. We knew that he was not going to visit the prisons. He didn't like prisons. We knew that he had never taken tours in his earlier cases, so it was hard to visualize how we were going to get the sight and the smells of prisons across to the trial judge, which is so important. You know, you lose that in the appellate courts, but it's important to get that before the trial judge. And so we made a decision on how to do our discovery. Fortunately, the Alabama prison system was one of the first to be computerized, and they had a lot of data. Judge Johnson told them and us, he said, I want full disclosure on discovery. I don't want anyone coming back here on motions to compel. They upset me. I want people to cooperate and get full disclosure. And he looked at the Attorney General, and we got quite full disclosure. They retained private counsel, which made things a little bit easier because the private counsel were a lot more competent than the then Attorney General as office. And we decided that one of the things we were going to try to present the judge with was a host of factual stipulations. And we did requests for admissions after our discovery, and we in fact got 1,100 stipulations presented to the judge a week before the trial, which really laid out by section on overcrowding, on mental health care, on classification, on fire safety, on sanitation, on violence. We had this all laid out with stipulations based on the admissions that we had elicited from the defendants. We also had a book of photographs. We had 300 photographs, which tracked the testimony of one of our experts, our environmental health expert, so that when the expert would describe entering this particular cell block and seeing the broken lavatories and the overflowing filth on the floor, there was a picture of it. And you could see Judge Johnson flipping the pages of there were 3 volumes of photographs as this public health expert was testifying. We had 7 other experts, classification experts, criminologists, prison officials from other states. By the way, it was interesting, not a single expert asked for a fee in that case. They all saw it as a very important public service, that this was going to be the first big statewide totality of conditions case. And that's what we attempted to prove, that all of the conditions by themselves individually might not have constitutional significance, but put together they created an environment that was cruel and unusual punishment, and that then the judge in his remedial orders could address each of these individual areas. We tried the plaintiff's case in 5 days. I mean, today, in other cases of similar dimension, we spend 3 months in trial. The Texas case, a much bigger case, bigger system, the trial before Judge Justice went on for 7 months. This, the plaintiff's case took 5 days. We rested. We thought we had proved a solid case. We had these marvelous stipulations based on the admissions. And then the state went on. This, by the way, is August of '75. We asked for but did not get a continuance. On the 3rd day of the defendant's case, they asked for a conference, and they came into chambers and said that they were prepared to concede that the plaintiffs had proved an 8th Amendment violation. I'll never forget this. Judge Johnson, who wore half glasses like this, looked down his glasses and said, Mr. Lamar being the private lawyer representing the defendant, you're telling the court then that the Attorney General and Governor Wallace they were the defendants, have authorized you to go into open court and concede that the plaintiffs have proved a gross violation of the 8th Amendment? Is that what you're telling me? Well, they hadn't planned to go into open court and do this because there was national press out there. but they got the message from Judge Johnson. When he puts his glasses and looks over them, you don't talk back to him. They went into open court and conceded the Eighth Amendment violation, got a lot of national press, and had probably more importance outside of the state of Alabama than in, because we got calls from other state corrections officials. What are these standards that the judge ordered? Because in his remedial order, he set forth various standards that they had to comply with to fix these problems. I mean, they didn't want to get hit with court orders like that. And so it had a great spill-off effect being replicated throughout the country. And I had the great pleasure, one of the horrors of the Alabama system was a building called the Dog House. It was a segregation building, windowless, 6 or 7 men in a 4-by-8 cell. That's a slightly larger than your average door in your home. 7 men in there, windowless, so crowded that they couldn't all lie down at the same time. They had, 4 had to stand while 3 lie down, with empty cells on either side of them. I mean, it was a real punitive kind of thing. He ordered that building destroyed. He gave us preliminary injunctive relief at the end of the trial, or immediate injunctive relief at the end of the trial, ordering that building closed and destroyed, and then, together with Judge Hand from the Southern District, they joined together in an order capping the state prison system at the design capacity and enjoining any intake until they got down to that design capacity. With some exceptions, if you got a murderer coming along, well, you could take the murderer in, but you had to release a property offender or something like that. So all of this got a lot of publicity, and the final decision there was in January of '76, and a great deal of impact. And the thing I want to talk about there was, during the trial, we noticed we had 2 plaintiffs there. We had asked the court, we would have a lot of plaintiff witnesses because we would follow each expert with live prisoners to put some flesh on their bones, to tell horror stories about what they were talking about, to talk about the assaults and the sexual assaults and the violence and the fact that prisoners were pulling teeth because they had no dentist there. And you wanted him to hear about, Judge Johnson to hear about this. But all of those would be sequestered from the courtroom because they were going to be witnesses. And so we asked that we have 2 prisoners there all the time. Worley James, the 78-year-old black man who had filed the original lawsuit, and a white man of about 60 named Bill Campbell, a jewel robber, longtime Alabama prisoner. Both of them could also be helpful because they would know if the wardens were telling outright lies about something, they would be able to tell us, no, that's not true, that doesn't exist in that particular prison. And they sat there in the courtroom for the entire 8 days of trial. And after the first day, we noticed, that as plaintiff's counsel noticed, that usually when you have a prisoner in a courtroom and there's a recess, either a lunch recess or in those days, Frank Johnson was a cigarette smoker, as I was. There were frequent smoking recesses. The prisoners would be shackled and taken into the marshal's lockup, down the hall. But Worley James and Campbell were just escorted out into the hallway. No shackles, no restraints. A few marshals discreetly, not in uniform, but maybe 10, 20 feet away, just leaning against the wall. And these 2 men would sit there. And many years later, I asked Judge Johnson about this. And he said, well, it was their case. They were plaintiffs. They weren't prisoners at that point. They were parties. They didn't seem to be dangerous to me. I mean, they had to be treated like parties in this court. And that fact, their presence there, their treatment, again, they were listened to and they were heard. And that was what was important about that, more than the great legal precedent, but that these prisoners, the lowest of the low, were heard. Some final reflections that I want to share with you. I think this country is in pretty dreadful shape. We have lost the capacity for collective moral discourse, and we lack moral vision. We ignore the hunger, the disease, and the misery of a substantial portion of our population. We debase our politics, we suppress dissent, we indulge in panic-driven ineffective but costly policies, and I'm talking about both parties now. This is not a political thing, it's a general thing. We indulge in panic-driven, ineffective but costly policies to deal with crime and drugs while reducing commitments to health care, housing subsidies, child care, and decent schools, and we label them liberal elitism. A review of Barbara Ehrenreich's book on the 80s describes yuppies as young people who, driven by fear, equate a respectable career in the helping professions with a year's internship with Mother Teresa, and then head for something really profitable like corporate law, international finance, or cocaine dealing. And lawyers have a role in all this and should be making a difference. In a Cambridge University publication, The Changing Values of Women and Men Lawyers, a study of lawyers practicing in a particular county in the state of Washington was reviewed. The author discovered that when lawyers talked about their work, they likened it to a game. People in other professions, doctors, teachers, ministers, scientists, seldom use the term game to describe what they do. For lawyers, an attitude of emotional detachment reinforces the idea that law is a game to be played for its own sake, with winners and losers, and the adversarial system makes it easy to maintain personal distance. News stories regularly describe lawyers in Miami who are involved in a debate over the ethics of representing drug defendants on a regular basis. The least onerous reason given by members of what's called the white powder bar for representing drug dealers was that everyone had a right to a lawyer of his choice. One lawyer who claims to have an annual income of more than $1 million, representing figures associated with the Medellin drug cartel, sees his clients as underdogs facing an overreaching government. Another claims to be fascinated by drug kingpins like Pablo Escobar, seeing them as historical figures, and justifies representing them for huge amounts of money. One lawyer was completely open about why he represented drug figures. It's a question of money. There's only one reason to represent someone charged with a drug crime, and that's money, big money. Another popular industry for lawyers is the lobbying law firm. There's been an explosive growth, and I thought of Judge Coffin as I was writing this section, and your time in Washington. There's been an explosive growth in this field that attracts lawyers who are willing to involve themselves less with courtrooms and the Constitution than with political fundraising and walking the halls of Congress. While some may be unable to find any cause for moral cheer in the newfound popularity of lawyer lobbying, one Washington lawyer who reportedly has an annual income exceeding $1.5 million a year argues that these are the kids who in an earlier time came to Washington to work for Jack Kennedy. Asked if the comparison might be flawed because the lawyer lobbyist today is working for wealthy corporate interests rather than president or the Congress, the lawyer replied, "They want to be involved in the system, and that's good." You who are law students are entering a profession that has enormous power and influence in our society. Much of it, I think, is being used unwisely, improperly, and often immorally. Lawyers must be prepared to take personal moral responsibility for the consequences of their professional acts, and our society can no longer afford lawyers who see themselves only as hired guns, and that's the end of it. I'd like to conclude by quoting from sections of two speeches given by one of my heroes, the Nobel laureate Elie Wiesel. They're not exact quotes because I've added a few of my words to his. After he received the 1986 Peace Prize in Oslo, he gave two addresses, the Nobel address, and then the next day the Nobel lecture. And this is a compilation of some things he said in both of them with my tinkering. There is so much to be done, and there is so much that can be done. One person, a Raoul Wallenberg, an Albert Schweitzer, a Martin Luther King Jr., one person of integrity can make a difference of life and death. We must try to be one person who makes a difference. As long as one dissident is in prison, our freedom will not be true. As long as one child is hungry, our lives will be filled with anguish and shame. What all these victims need above all is to know that they are not alone, that we are not forgetting them, that when their voices are stifled, we shall lend them ours. That while their freedom depends on ours, the quality of our freedom depends on theirs. There may be times when we are powerless to prevent injustice, but there must never be a time when we fail to protest. The Talmud, he said, tells us that by saving a single human being, woman and man can save the world. I hope that each of you will try to be one person who makes a difference. Thank you.